The digital age on the global stage. Can the law keep up? Yes! Bravo! It's only going to go uphill from there. I am Jeff Rosen, the president and CEO of the National Constitution Center. Every time I introduce the National Constitution Center, I have to recite our exciting congressional mandate. The National Constitution Center is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And it's this beautiful museum in Philadelphia on Independence Mall, for those of you who haven't been there, but it's also the National Center for Debate and Education about the Constitution. And we've just started up a really exciting partnership with the American Constitution Society and the Federalist Society that's sponsoring a series of traveling town hall debates on constitutional issues. And the next one is in New York next Tuesday, July 16th, at the University Club, 6:30. The question, resolved, the metadata NSA surveillance violates the Fourth Amendment. And it's Michael Mukasey, the former Attorney General, against Deborah Pearlstein of Cardozo Law School. And this is one of a series of debates that are traveling across the country that we think, like the Lincoln-Douglas debates, will transform constitutional discourse in America. And it's really very exciting and meaningful to all of us at the NCC and ACS and the FedSoc to bring together the best constitutional minds in the country for debates and podcasts and symposia to have civil constitutional debates. So thanks for checking those out. I think that this panel we're about to have is very much in that spirit. We have the most interesting of all topics facing the country today. That is the future of digital privacy and free speech. We're going to give it a global dimension as well as focusing on US developments. You have here the dream team, and my only job as the moderator of this all-star cast is to keep things, it's going to be a psychedelic sort of wild ride, but I'm going to just keep things moving along, and we're going to have a great freewheeling conversation that will educate all of us. So let me very briefly introduce these distinguished constitutional thinkers, and then we will jump right into it. I think the main housekeeping I have to remind you to do is please turn off your cell phones. We'll go for about an hour and then take your questions. And here we go. Oren Kerr is Fred C. Stevenson Research Professor of Law at George Washington University Law School and my dear GW colleague. Greg Noheim is Director of Freedom Security Technology Project at the Center for Democracy and Technology. Kate Westmoreland is a non-resident fellow at the Stanford Center for Internet and Society. Anupam Chandler is director of the California International Law Center, professor of law at the University of California at Davis, and since he's the only one who's given me his recently published book, I can plug it, the author of the absolutely electrifying The Electronic Silk Road, How the Web Binds the World Together in Commerce. Really look forward to hearing about that. And Miki Yang is director of the National Security Program at the Third Way. Okay, we have a lot to talk about. I just, for my own purposes, want to begin with the Patriot Act, Freedom Act debate. And I want to understand, first of all, what exactly the Freedom Act does, and whether or not it, in your view, panelists, is or isn't consistent with the Fourth Amendment. We had a very interesting discussion at the Constitution Center recently. Rand Paul and Mike Lee came within a week of each other. And first of all, both Rand Paul and Mike Lee loved the Constitution Center. They said, this is like Disneyland, constitutional Disneyland, do I ever have to leave? They both took selfies with our statue of James Madison and said, could you imagine that the federal government would have so much power delegated to it? But Rand Paul and Mike Lee, who are two principled libertarian conservatives, disagree about the Freedom Act. Mike Lee thinks it's a sensible balance between privacy and security, and he co-sponsored the Freedom Act with Senator Pat Leahy. On the other hand, Rand Paul thinks that it gives away too much and invokes Louis Brandeis for the proposition that surveillance that collects a tremendous amount of information about us, even with a warrant, may violate the Fourth Amendment. So I'm really interested in the panelists' views about that subject. And Greg, why not begin with you, because you follow this debate so much. Tell us what the Freedom Act does, first of all, and whether you think it is or is not consistent with the Fourth Amendment.
Thanks, Jeff. I appreciate it. I don't have a book. I do have a website. It's www.cdt.org. So the USA Freedom Act, I think, is a very big deal for what it does. and for the symbolic accomplishment of reining in NSA surveillance. Before the Freedom Act, if I made a call with this guy to you on your guy, and the call was completed, the NSA would get a record of that call. It would indicate that I called you at this time and spoke with you for how many minutes, and they would keep that record. And then they could mine that record for intelligence investigations. They could mine it on their own with no permission. The White House put in a process where they would first go to a judge. It was optional for them, but that was the rule before the Freedom Act. After the Freedom Act, if I make this call to you, they're probably not going to get it. The NSA, the government, probably wouldn't get the call unless one of us was talking before that with someone who was interesting to them, meaning that they had some reason to believe that that other person was involved in terrorism. So I think that's a big accomplishment. That's a big deal. It used to be they collected or tried to collect a record of every phone call, and now they only get a record of every call that is to or from one of these suspicious numbers, and they have wide discretion under the bill to decide what's suspicious. They also get, and this is probably the part that most troubles me, they also get a second hop. So it's not just who called that number, but also who called that number. So it's it's a compromise, but it's certainly better than where we were.
And how do they get it? What's the procedure and standard for getting the number?
So before, the rule was that phone companies every day would send their phone records, all the calls made and received, all their customers, to the NSA. After the Freedom Act, the government will take the number to the providers and say, who called this number? And now they would say, who called this number? And the reason they have to do it that way, Jeff, is because the numbers that they're talking about are not the numbers that are the phone numbers of, say, Americans and their provider is Verizon. For those calls, they just go straight to Verizon. They go straight to AT&T. They go to T-Mobile or Sprint. It's for the call handled by the provider in Afghanistan or in Pakistan. They can't just go to the foreign provider and say, hey, give me a record of your customers' phone calls. That's not going to happen. So they had to have an alternative way, and this is their alternative.
And last factual question, no warrant or reasonable suspicion, they just ask for it and can get it?
No, there is a standard. It's a low standard. The number has to be associated with terrorism. I think that's the language. I don't have it in front of me, but it's not a high standard. The key accomplishment in the Freedom Act was the way they dealt with the DOJ's misinterpretation of prior law. DOJ said every phone call made in the country is relevant to a terrorism investigation. I think that can't be right. The FISA court thinks it is right. Was it the 11th Circuit? Second Circuit said, no, that's wrong. To get around that problem, the Freedom Act doesn't try to redefine relevant. Instead, it says, even if it's relevant, your collection has to be based on a specific selection term. And for the phone call records, those terms are things like a phone number, a device ID, that kind of thing.
Great. Well, I'd love all the panelists' thoughts on aspects of this. Kate, you've studied the interplay between U.S. and international law. Will foreign governments be reassured by the fact that the data is now being held by the phone companies and not collected by the U.S. government? And what do you think of the Freedom Act?
I'm not sure on that one so much. I guess the context that I come to it from is a lot more the criminal side of this rather than the NSA and Intel side. And I think one of the things that's interesting in the way that this debate has opened up over the last couple of years is that we started thinking about it in the security context, but now also thinking about it from the law enforcement perspective, and to be thinking about what are the standards that are appropriate for law enforcement and what are the standards that are appropriate for intelligence purposes, and how do we delineate those? And I guess I've spent a lot of time thinking about the challenges that there are in legitimately accessing information across international borders where you do have to meet the probable standard cause. And I guess it's interesting to see the interplay, but I'll probably defer to some of the others on the Intel side.
Is it harder to get this sort of information in Europe than it is in the US after the Freedom Act?
I'm not sure. I'm probably not the best one to talk on that.
Great. Oren, did the Freedom Act give away too much?
I don't know. I don't really have views on the policy merits of it. That really, I think, boils down to the effectiveness of various means of surveillance and what the actual privacy risks are. And I think it's actually really hard as members of the public to get answers to both of those. We naturally sort of intuit based on where we fit on the ideological spectrum. Some will fear government surveillance and privacy harm. Some will fear terrorist attacks, and people will sort of organize themselves on that line and have views. But we can talk about the constitutional issues, but I actually think from a policy standpoint, I'm just not sure what the right answer is.
Tell us about the constitutional issues. Did you think that the 215 collection raised constitutional issues, and are they cured by the Freedom Act?
So I don't think the metadata program that existed before was unconstitutional, implicated the Constitution, because metadata collection is not a search under the Fourth Amendment, and since it's not a search, it can't be an unreasonable search, and then it can't violate the Fourth Amendment. So I think the Supreme Court's decision in Smith versus Maryland that said that numbers dialed from telephone is not protected under the Fourth Amendment was correct, and it applies a technology-neutral approach to the Constitution as you switch from physical surveillance, telephone surveillance. We can talk about internet surveillance next, and that it's correct to say that the Fourth Amendment protects the contents of communications, but not non-content information. And from that perspective, there's no Fourth Amendment search involved in metadata collection.
Miko, do you agree with Oren that there was no Fourth Amendment search involved in metadata collection?
So I think this is a question where I think there are people who question Smith versus Maryland's continued relevance. No one's opined on that yet, so we don't have law on it. But I think there are a lot of people who feel like today, given the amount of metadata you can collect and the amount of information that you can build on someone, that the kind of metadata that you have and what you can know does have privacy implications and Fourth Amendment implications. Whether or not the courts actually find that way, I think we don't know yet. But just to correct something that Greg said, the program as it existed before, intelligence officials have talked about the fact that it was actually not mobile collection, it was just landline telephony, and it was inside the United States. I think that there are also questions about the purposes for which the information is collected, and when we're talking about it in the context of law enforcement, you have Fourth Amendment concerns. This particular program, because it was operating inside the United States, I think is squarely inside Fourth Amendment concerns. But there are other surveillance programs that people are more concerned about where the collection is aimed outside the United States, and there I am not convinced that a Fourth Amendment analysis is at all appropriate, and certainly the government would argue that it's not appropriate.
I'll ask you about those international programs in a moment, but just because you've written about this, Miko, the Second Circuit did hold very squarely that the metadata collection was not authorized by 215, and the lower court opinion by Judge Leon held squarely that massive amounts of data collection without a warrant do violate the Fourth Amendment. Do you want to just, is calling into question Smith versus Maryland, essentially. Do you want to help the audience understand what those arguments are?
Yeah, I think that's right. I mean, one of the challenges here is that because Congress passed USA Freedom, actually the Second Circuit opinion is now moot because they found it did not meet, it was not justified under the existing statute, but didn't actually reach the constitutional arguments. But there are a lot of people who would argue, and when you look at the kind of technology that you have now to evaluate patterns of life and personal information from metadata in a way that you couldn't necessarily before from vast patterns of information. I think people are concerned that you are now looking into, that the non-content information tells you enough to raise a Fourth Amendment concern.
Great. Okay, Judge Chandler, Justice Chandler, you've heard the arguments on both sides of the Freedom Act. What is your view, I suppose, both as a policy matter and as a constitutional matter of the Freedom Act?
So the Fourth Amendment, of course, protects Americans as it's understood by the Supreme Court. It doesn't protect foreigners outside this country. So imagine if you're hearing this debate and you're not in the United States, if you're one of the 19 out of 20 people who is not American, you aren't actually, so you aren't actually covered at all all by any of these protections. And so so even if the USA Freedom Act actually does do substantial improvements towards the protections of Americans, and I think it does, it doesn't do anything to protect the 19 out of 20 people who live outside this, who happen to be fortunate enough to live, or unfortunate enough to live outside this country. In fact, the mass surveillance apparatus operates entirely not under 215, but under 702 of the FISA Amendments Act, and there are no holds barred, essentially, on what happens elsewhere. So when President Obama, in the wake of the Snowden revelation, said to Americans, I want to assure you that we're not collecting information about you, doing so indiscriminately, et cetera, which seems false, actually, even when he said it. But that offered no reassurance at all to people outside this country. And even in the wake of the USA Freedom Act, it is the USA Freedom Act. It is not the Freedom Act for the world. It shows a shocking lack of concern over anyone outside these very borders. So I think we need to be asking our government to show that it cares about people outside the country, not just people within the country. We need to ask Congress this. And I think that's because there's a self-interest involved. One, the collection of information under 702 can be used as a backdoor to collect information about Americans. That is, you can follow a 702 process to potentially that's consistent with 702 outside the United States, and then use mass selectors to query that data about Americans. So one, there's that self-interest, and two, the reality is that not all information about Americans is going to be kept within the United States in any case. We are going to be using more and more global services, and that's what we should like in a kind of world of free interflow. And that means that our information will be held abroad. And so we should want a world where governments respect other peoples outside their borders, and we should set an example in that stead.
Great. Thank you very much for setting on the table our second topic, which brings us to our second round. This feels like Jeopardy now that Alex Trebek is gone. We have to maintain that spirit. And now, Greg, let's take up this question of the surveillance of non-citizens abroad. Describe, Anupam has flagged Section 702 of the Foreign Intelligence Surveillance Act. Tell us, as clearly as possible, what authorities are being invoked to spy on non-citizens abroad and what the implications are for American citizens as well.
So the news is not good for people who are abroad and who are non-Americans. It really is the Wild West. Two authorities. One, the Executive Order 12333, that permits the government to monitor communications to collect foreign intelligence, and foreign intelligence is defined so broadly as to include any activity or intention. You don't have to be acting, you could just be intending, of a foreign person. That's not a meaningful limit. And so when I say it's the Wild West, it really is. There are not meaningful protections against surveillance for people who are not Americans and who are outside the United States. When it comes to targeted collection through the use of U.S. providers, compelling a Facebook or a Google to disclose information about people who are not U.S. persons and are abroad, the news is a little better, but not much. They have to have a foreign intelligence reason, again, and the foreign intelligence reason is defined more narrowly, but it's still defined quite broadly. The purpose could be to collect information that is related to U.S. national security or related to foreign policy. That's enough, and that's nothing. So with that information, they can go to a Facebook or a Google or another company and compel that company to disclose information about this this non-U.S. person abroad. And they use selectors to do this, tens of thousands of selectors each year are targeted for this kind of collection. The 12333 collection, again, it's even broader. It permits bulk collection, meaning programs that, for example, collect all of the communications to or from an entire country for a period of 30 days. You know what? There's no selection there at all. It's just collecting everything in bulk. Another bulk program is cutting into the cables that run underseas and connect the different data centers of the large U.S. providers. You know, you cut into one of those cables, you're going to get the whole take, and the whole take is going to include a lot of communications of U.S. persons, not just the foreigners. So, you know, I think a lot has to be done to rein in the surveillance under the executive order. The Privacy and Civil Liberties Oversight Board has a program to figure out what ought to be done. I think it's a massive problem, and we really haven't begun to kind of scratch the surface of coming up with reforms.
Wonderful. Well, Miko testified before the Privacy and Civil Liberties Board at the Constitution Center just a few weeks ago. So I think we can go out of order. Let me ask you, what kind of oversight do you think is necessary? What concerns do you have about this statute 12223, and what are the consequences for U.S. citizens as well as foreigners abroad?
So that's a lot to cover. Just without commenting on the veracity or contours of any of the particular intelligence programs that Greg may have outlined, as bound by previous non-disclosure agreements, I would say that there are a couple things. One, 702 collection, which is aimed at compelling American providers to give information. There are significant oversight mechanisms within that regime. It may not be sufficient for Greg, but it is certainly more oversight within that program than there is under 12333. And I think when people are really worried about surveillance, a lot of time what we're worried about is is surveillance that it goes for a political purpose, right? It goes to what we think of as First Amendment concerns and having the chilling effect, or could be used to politically persecute people. Having worked on the 702 program, there are enough oversight mechanisms in that program that I think the risks of that particular program being misused in that way are lower. Because of the oversight mechanisms, the reporting to Congress, the IGs, and the way that the community itself has come under scrutiny. Aside from the lack of statutory checks in the system, there are significant internal administrative checks, and when they've gone back and done audits of the program, I know a lot of conservative defenders of the program say this as to dismiss it. They haven't found allegations of intentional abuses. What they have found are people with what we would call love-int, right, putting their ex's selectors in to see who they've been calling, that kind of thing. But it's not the kinds of pernicious Nixonian political purposes that we would be worried about.
Isn't that worse?
Those people are punished, right? Like, it's very clear that, like, they take administrative action against those people. They just don't tell you who they are or what's done about them. But the community takes those kinds of violations very seriously. And those are sort of one-offs, right? Like, what I think you're really worried about is someone saying, I'm going to look at people's political donations or connections with a political party in another country or things like that. And we haven't seen those kinds of abuses happening inside the system. The 12333 collection also has within it certain guidelines for minimizing, what they call minimization guidelines for the protections of Americans who might be incidentally collected. And so there are some protections in there. The other thing to keep in mind when we are concerned about surveillance and what we do is that the U.S. government actually has stronger oversight mechanisms for its surveillance than other countries. And I know it doesn't make people feel better to say, well, we're a lot better than Russia and China, because, God, we better be, right? We are also, in fact, better than most European democracies. The intelligence committees, and I served on one of them, meet regularly, meaning like more than once a week, and they ask very hard questions of the intelligence agencies about the programs that they are running. The German Intelligence Oversight Committee meets once a month. the staffing on those committees are, you can count them on your hands. The staff on the intelligence committees in Congress are much more robust. We're talking, 30 people on each side, plus some people who are assigned to various senators. And what you have seen, particularly with the CIA torture report coming out of the Senate, is that you do have opportunities to have very robust, independent oversight coming out from those committees. That's not to say it's perfect. That's not to say that there aren't ways in which they can tighten up protections. But the other thing to remember, and this is something that Anupam was talking about, that when we are talking about national security and these surveillance programs, they are conducted to protect the country under the president's commander-in-chief authorities outside the United States. So when we are talking about the extraterritorial application to the privacy rights of foreigners, there's very little law on this, and we may, as a prudential matter, want to treat other people the way that we would want to be treated. There's nothing in the Constitution that says that we have to do that. And so when we are talking about, Greg says tens of thousands of selectors, when you think about how many people are in ISIS, the number of selectors alone is not the concern. Right? There are a lot of very bad people out there that you want our government keeping an eye on. The question is, what's the overage? And part of the problem is that the amount of secrecy that we have in oversight of the programs means that the public doesn't know what the overage is.
Kate, do you agree with Mickey that the U.S. oversight of the data collection of non-citizens is more robust than that in Europe? And what is the effect of U.S. surveillance of non-citizens on our relationship with foreign governments?
I agree, and from what I understand, that actually, in terms of the oversight, the U.S. system it's ahead of many of the other countries in the world. I guess the point is that most of the other countries in the world don't have the same capacity. To be honest, a lot of us they'd love to be able to do the same things, they just don't have the resources. So the fact that the NSA has so many more resources than any of the other countries, that they're able to have these sorts of mass surveillance programs that, to be honest, I think a lot of the other countries would probably like to be able to have if they had the resources. I think it's relevant to point out that when you're thinking about the protections and whether they should, what should apply to non-US persons, it's more than just the sort of do unto others as you'd want them to do to you. There's also the impact that it has on US businesses, and I guess you're seeing the big companies and the roles that they're playing in this, because they can't grow their businesses just serving US persons, that there's strong economic interests in wanting to be able to engage with the rest of the world, and they're certainly seeing the amount of skepticism of US-based companies, and they're having to sort of fight back on this. So I think that's another important angle to this, about how does the policies that we have here towards non-US persons, how does that play out for the economic interests as well?
Oren, I'm very interested in your take on this. First of all, going back to first principles, do you think the court was wrong to draw such a sharp distinction between citizens and non-citizens constitutionally? And is there a case that non-citizens should be protected when U.S. officials are surveilling? And also, is there a danger that the data of U.S. citizens will be swept up in imperfect algorithms with these broad foreign surveillance powers?
Great. So the first question was about the Supreme Court's decision in a case called United States versus Verdugo-Urquidez, going back to 1990, which held that a citizen of Mexico did not have Fourth Amendment rights against the search of his house in Mexico by a joint investigation of Mexican and United States authorities. The holding being that the Fourth Amendment gives rights against unreasonable searches and seizures to the people, and the people means those within kind of the U.S. polity. Those citizens, non-resident aliens, could be a lot of people that are inside the United States, but not people outside the U.S. who don't have any voluntary connections to the U.S., except at least in the Verdugo-Urquidez case, sending a lot of drugs into the U.S., which is what he was convicted of doing. So I think that's a sensible line to draw. I mean, it makes sense to me that the Fourth Amendment and the constitutional rights more broadly would have some sort of a social contract notion. It's we think of where rights come from in a democracy as coming from the consent of the governed, the notion being that people have a way of contributing to what the rules of law are, and that therefore those rules of law affect them, and that's why it's okay. and the idea of limiting at least Fourth Amendment rights to some sort of group of people either inside the U.S. or people even outside the U.S. but who have strong connections to the U.S. I think that's a sensible line to draw. A line has to be drawn, I think, at some point, and the question is where. And although the Verdugo or Quitas line itself is pretty murky, I think it draws at least a plausible line. In terms of what about the risks of U.S. persons, U.S. citizens having their information collected incidentally, of course there's that risk. It's a reality that's going to happen, not only because every large government program is going to have errors. The government program, it's not going to function perfectly, except from the Federal Society side, so we assume that to be the case, or maybe sort of news here. But so it's a large program, of course it's going to happen, but also the nature of communications. I mean, you may communicate with people outside the U.S., you might have friends abroad, you might have traveled abroad, I mean, all sorts of reasons why these communications will be picked up. Does implicate Fourth Amendment rights, in my view, so there are Fourth Amendment issues implicated there. Really boils down to the reasonableness under the Fourth Amendment, and exactly what the reasonableness standard is something that the courts are still trying to figure out. So it's an issue, and it's an inevitable issue, but it's really, I think, one that can't be avoided, and one that we're just going to have to develop some sort of standard to address.
Can I follow up on that?
Sure.
Oren, you're one of the best thinkers on these things, and it just strikes me that this incidental collection issue is a really big deal, particularly on the 702 collection and on the 12333 collection. What should a court be thinking about in terms of making that reasonableness assessment? How is it the numbers of U.S. persons' communications that are collected in the particular program or the particular wiretap? How would you advise the court if you were giving advice?
Yeah, it's a hard question because the Fourth Amendment rules are usually case by case, not kind of programmatic. So we're talking about like a massive program, which itself is hard to kind of get your hands on. Like, what is this thing? We've got a statute, and then we've got individual collections under the statute. Should we be looking at kind of the reasonableness of the statutory scheme? Is it the reasonableness of how it's applied? How do you know that? If it's
so, say they
all really hard. I'm trying to avoid the question.
Say they go up.
It's hard is maybe the way of putting it. It's a really tough question.
Say they go up on my cousin in Lebanon, okay? And my cousin in Lebanon calls me and his other cousins in the United States a lot. 15% of his calls are to us. Would that be reasonable to say you can wiretap that my cousin?
So I think the question would be, if you're, say for example, your cousin happens to, unbeknownst to you, to be a terrorist financer, then it would be reasonable. But so there are circumstances by which
you're under 702, so you don't really have to make any showing like that to anyone. You don't even have to convince yourself of that.
Right, no, that's true. But the thing is, you identify selectors under 702 that fall into particular buckets. So WMD proliferation, counterterrorism, espionage, perhaps they think that, hey, look, this is a number that gets called frequently by the Russian embassy, so perhaps we think it's this. They come up with lists, and this is not, to be clear, under 702, it's not bulk surveillance like we had under 215. Like people talk about, well, we're looking for a needle in a haystack, so first we have to build a haystack. 215 wasn't just building a haystack. 215 was a government monopoly on hay. It was every piece of metadata that was traveling through the country at all times. 702 is in fact giant haystacks. It is giant haystacks. The numbers are large, but the amount of information the government is interested in is large. So there is some tailoring under 702 that didn't exist under 215.
But the question is, when do you cross the line into having an unreasonable search based on the incidental collection of Americans' communications? That's the question. It's a question for 702. It's a question for 12333.
But so for Greg, I think the question on that comes down to not is when is the volume of collection, but actually, and we had this debate internally, when is there the search? Because if you're building the haystack, but you don't look at most pieces of hay, is there a search just because you have the haystack if you never actually went in and analyzed and pulled that piece of hay out? Now, there are not, you can argue, and I think that it might be a good place to start the argument, that there are not constraints on the government when they reach into that haystack to say, all right, what you're looking for in the hay, that's a reasonably tailored search term to get in there. But a lot of people have argued because you're not all of the hay will be looked at, that the privacy interests in the whole haystack are lower than the privacy interests than if you were particularly targeting a person. people can debate that. I think that's a public policy debate worth having.
All right, I'm going to let Anupam adjudicate this question. And in the immortal words of Stephen Colbert, are you pro-needle or anti-haystack?
So I guess I would take the position that I'm pro-needle. In fact, one question was raised about the oversight under 702. There is oversight, but again, it's limited to protecting U.S. persons, right? The targeting and minimization procedures in 702 are about U.S. persons, not about people outside the United States. So the oversight has a narrow ambit, which is making sure that U.S. persons, I mean, whether you think the oversight is sufficient enough to protect U.S. persons, it doesn't even try. Its goal is not to protect people outside the country, right? So there's, as I said, no holds barred, with respect to people outside. So the oversight just fails entirely. It's not oversight of what we're doing with respect to people, the 19 out of 20 human beings on this earth.
So the administration announced within the last couple of months that they were extending PPD 28 and minimization guidelines to non-U.S. persons. And they are talking about that as a big thing that everybody who engages in surveillance should do. Whether or not the minimization guidelines are sufficient protection is another question, but they tout it as, and I haven't seen how it's actually working in process, they tout it as extending the same protections to Americans that they're extending to non-Americans.
So in January of 2014, President Obama, through the presidential policy directive, began this process of saying, and he actually used the term, we need to respect the dignity of people outside the United States.
Not the rights.
That was
not the rights.
Not the rights.
Isn't that
yes.
interesting?
So there is a tiny movement in this way, but it's done purely by these Obama administration decisions, which who knows, may or may not survive for a long time. So 702 in itself has no such requirements.
Anupam, I want you to set up our third topic, which is what are the Europeans doing? They are trying to implement more stringent privacy rights across borders. They're more universalistic, reject a strong distinction between citizens and non-citizens, and seem to extend similar rights to both. If I were in France, what would the French government be doing to spy both on me and on non-French people?
So the Europeans, and I'm not a European law expert, I don't claim an expertise I don't have, but the general approach seems to me consistent with what has been said earlier, which is that the Europeans also have surveillance capacities and allowances in their own law, which rival that of American law. And so the Europeans, as a governmental surveillance matter, are not any better, perhaps. And the question is exactly what, how you measure their capacity versus the allowances, the affordances in the law. I think, as Kate pointed out, their capacity is much more limited than the American capacity, which may explain the lack of the number of staff members in Germany, because they're overseeing a much smaller apparatus to some extent, right? Our apparatus is much larger. I think the European side, and I would like to bring this in as well, there's been an effort to go after corporations and not governments per se. And so there, I think there has been a kind of protectionist impulse at work as well, which is this kind of perfect storm. We take the Snowden revelations that say the US is surveilling the world. We take the existing reality that US corporations tend to dominate the global internet space. Well, if we want to reject the U.S. surveillance, we reject American corporations. That's the kind of logic that the Europeans seem to be enamored with. I think it's a false logic. The U.S. surveillance, as I've suggested, operates very much outside the borders of the United States. It's not just simply the U.S. companies that are involved in that surveillance apparatus. And it also is fundamentally protectionist, which I think we should all be irritated about.
Miko, is this basically anti-American protectionism, as Anupam suggests, or does it reflect a principled commitment in Europe to dignity rather than liberty? There's a wonderful article by James Whitman which talks about the different conceptions of privacy and talks about how Europeans are much more willing to restrict private corporations because of their historic commitment to dignity, whereas Americans, which have been focused on liberty, are much more interested in restricting the states and not the private sector. Which is it?
So I think that's true that the U.S. is more interested in preserving liberty. But I do think that a lot of this talk from Europe is protectionist and anti-American, especially because the European intelligence agencies to a large extent benefit from the take from American intelligence agencies. So they're talking out of both sides of their mouths when they say, look, you guys shouldn't do this, because they're more than happy to receive the intelligence that we provide to them about terrorist threats inside their countries. And our intelligence services have been very public about talking about the terrorist threats that we have helped them interrupt in Europe. And then you also see Europeans taking much more aggressive steps to force, particularly the British, to force the building in of backdoors and company compulsion with their surveillance apparatuses in a way that, we have some compulsion here, but we haven't moved to the same, we have not been able to compel encryption backdoors as much as the current and previous Attorney General and the Director of the FBI might like to. Typically in the United States, when there have been efforts to try and tell companies how to build their products, those have failed. And I would expect that to continue because we would value the freedom of those companies. The other thing to think about when we're talking about the rights of foreigners and how we affect them is one of the concerns the intelligence community often has is what are the blowback implications to Americans abroad when they conduct intelligence programs if they're discovered. And one of the things, and this goes back to the economic harm that Kate was talking about, is that you are really seeing very significant blowback concerns against American companies whose participation, either witting or unwitting, in these programs has been revealed. And so it is in many ways, especially for Congress, it's through the lens of those U.S. actors, those U.S. corporations, that we see a move to try and protect, to move into additional protections abroad, because there are questions about like what happens to the integrity of the American company who's trying to hold their data when, as has been alleged, the U.S. government goes and just takes it without asking.
I have to say, I think that the Europeans have a point, and it's not being adequately appreciated by the U.S. intelligence community. Their point is this: if you're going to listen in on my communications, you ought to have a good reason. If I was in the United States, you'd have to have probable cause. That's a good reason. If I'm abroad, all you need is that I'm abroad. That's not a good reason. And I think they have a good point. We signed a treaty where we agreed to extend human rights protections, a human right of privacy protections. We say that that treaty obligation doesn't apply outside of our borders. We're pretty much alone on that. So I think the Europeans have a point, and I think that we have to certainly respect it a lot more. I do agree that when it comes to domestic surveillance, the U.S. tends to have a better structure than in a lot of other countries, but when it's outside the United States and it's bulk or targeted at non-Americans, the Europeans have a point.
So, Oren, help me understand Greg's allegation. He's saying that when it comes to domestic surveillance, the U.S. government is more constrained than the French government is when it's spying on its own citizens. But when it comes to spying on non-citizens, European governments are more constrained. Is that correct?
So my understanding, I'm not an expert in European surveillance law, but my understanding is that U.S. Law and attitudes in terms of just public opinion draw more of an us-them distinction than do the laws in Europe. So whatever the standard is that's set in Europe, it's one that's more likely to apply both inside the country, outside the country. And at the same time, I think it's important to realize, for example, with U.S. law, let's say you're a U.S. citizen or a U.S. permanent resident alien, if you go outside the United States, you keep your Fourth Amendment rights. You still have rights. It's not like as soon as you get onto the plane, suddenly you have no constitutional rights at all. The standard just shifts to reasonableness instead of the warrant standard, at least according to the courts of appeals that have addressed this so far. And the difficult question is, what is this reasonableness standard? And courts have offered kind of different answers, but they've agreed, at least so far, that there's no warrant requirement abroad, in part because who do you go to get the warrant? I mean, do you approach a judge in the district court in Paris and say, give us a U.S. warrant? They're not going to want to, what is that? And what if you issue a U.S. warrant, you can't hand that off to foreign officials. So usually U.S. officials work together with foreign officials to conduct law enforcement surveillance, and in that case, the courts usually defer to foreign law, interestingly, whatever the standard is abroad. And that standard was introduced in the 1980s in a Ninth Circuit opinion by now Justice Kennedy, interestingly. So it's an early use of foreign law in the interpretation of the U.S. Constitution in the context of these joint investigations.
Kate, does this distinction between us and them make any sense in an age of global data flows?
Good luck.
Now the big question. Pulling out the big guns.
I've been waiting for these. Thanks for lining it up, Jeff.
Big question.
I think we're all struggling with it, and very much not only in the surveillance context, but in the criminal context as well, where I know that we're all closely watching the Microsoft challenge at the moment over a search warrant over data that they say was held in Ireland. So they refused to hand over the content of those emails, saying that that's extraterritorial. And that's, I mean, to be honest, they'd been happily handing it over for however long previously. And then last year decided that, no, this was going to be extraterritorial and they'd fight it. And this is the first time that this issue has come up. And we're all sort of scratching our heads on the one hand. And I can sympathise with much of the Microsoft arguments that you're like, well, this data is held in a data centre in Ireland. We don't actually know the nationality. It's not public, the nationality of the person involved, but presumably they're not a US citizen. But the fact that it's a US company that holds that data, does that mean that it should be US law that governs it, or should it be the Irish law? Should they still be entitled to the Irish privacy protections? And it's
What's the answer?
The government is saying, well, this is ridiculous. Microsoft, you're right here. You can access it via, you just need to click the right things and you can control that data. And so you should be the ones who control that. And I can see some attraction to that as well. As a user, when you sign up for a Microsoft account, at some level you realize that you're doing business with a US company. So it's not completely out of the blue to then find that the US law is implicated. But I guess, and this is exactly where all those economic and gnarly questions of international jurisdiction come head to head as to how do you manage those, the business. This is terrible for Microsoft's business model, that the rest of the world, the 19 out of 20 who are not US citizens, don't necessarily trust the US legal system or want to feel like their data is being controlled by those laws.
Well, speaking of these jurisdictional issues, Greg, tell us what the MLAT system is and what CDT is doing to end pressures on it.
Well, I don't know that we have an answer for all that, but the MLAT system is a way that that one government can trigger the mechanisms at another government to compel the disclosure of, for example, user communications or other evidence to be used in a criminal investigation. So, for example, what Microsoft is saying in that Microsoft Ireland case is, yeah, we've got our data in Ireland, and yet the Americans want to get it. So what should they do? Should they come to us? No. They should go to the Irish authorities and say, we're triggering the MLAT treaty between Ireland and the United States, or a multilateral treaty, and we want to get this information. And here we are, we're going through the steps required by this treaty. Please turn it over to us, or compel, or compel us to, or compel it the way it has to be compelled. That's the world that Microsoft is asking for. There is something maybe not so good about that world that we don't talk enough about. Say it's an Irishman, and you're the Irishman in Ireland, and say U.S. law, which requires a warrant issued by a judge based on a finding of probable cause, is actually more protective than the Irish law, which might not require a warrant issued by anyone who seems like a judge. Which one does the Irish person want? Mine because it's mine? My law because it's mine? Or the American law because it's more protective? And who are the Americans to make that decision for the Irishman, right? I mean,
maybe when you sign up for a Microsoft account, you can click U.S. law.
The fact is, I'm glad you said that, because when you sign up for the Hotmail account, they ask you, where the heck are you? And they ask you that because they're going to locate data related to your account close to you, because it helps them provision it faster. It helps them provide the service better. So one of the arguments that the government made was, hey, wait a minute, you don't want the person signing up for Hotmail to be able to game the system by choosing their law.
Or, and given the choice, would Europeans, when they realize how protective our law is, choose us over Ireland?
No, I think, and I'll give you a story that's helps explain this. I was at the Justice Department from 1998 to 2001 doing surveillance law, and I had a lot of opportunities to discuss surveillance laws with representatives of other countries, European countries, others in North America, to compare what the different laws were. And I would often be asked, representatives from other governments would say, wow, what you guys do in the United States is incredibly controversial. You violate privacy. What you do is massive scale surveillance. Remember, this was before the Patriot Act, before 9/11. This was the pre-Patriot Act. And they said, what do you do? Tell us what you do. And I would explain to them, this is what the U.S. laws say, and this is what the government does. And they would say, oh, we do that. No one objects when we do it. How odd that people would object that you guys have that same power. So I think what's going on is really a perception, and then there's the reality and there's the perception, and it's understandable if you're citizen of some country, you don't know what powers your own government actually has, what powers the United States has, and if the Snowden disclosures taught anything, it's actually you can think you have one set of rights and protections, and it may be that a court has in secret interpreted the laws differently, and you were wrong. So who do you trust is really the hard question, and so I don't think you can sort of analytically explain, here are the laws, which do you want, because the issues of trust are going to drive that more than anything else.
Great. Well, I think this leads to one of the juiciest topics in the clash between European and American law, and that is the right to be forgotten. We are shifting here from privacy to free speech, or rather to the intersection of free speech and privacy. The European Court has just recognized a sweeping new right to be forgotten, which derives from the French droit à l'oubli, or the right of oblivion, which is extremely French. Right out of Sartre. And the idea is that if you object to any data concerning yourself, if you're a European citizen, you can demand that Google or Facebook remove it, de-index it. And if Google or Facebook failed to remove it, and if a European Privacy Commissioner later decides that it's not in the literary, scientific, or public interest, then Google and Facebook can be liable for a substantial fine. In early instances, it was up to 2% of Google's annual income, which is last year $50 billion, which concentrates the mind. So my first question to you, Greg, is this is obviously a dramatic clash between American notions of free speech, which hold that truthful but embarrassing information is protected, and European notions of dignity, which say that people need to be protected. Is it sensible for the Europeans to delegate to lawyers at Google the decision about what's in the public interest in Ireland, and how do you think this thing is going to work?
So I think that the court really created a whole lot of questions. How would Google answer those questions? I mean, the questions are things like, is the information still relevant? Relevant to what? How does Google answer those questions? I thought that the right to be forgotten decision was, of course, it's very different from what you would get in the United States. In the United States, I think the balance between privacy and free speech comes out elsewhere. When you look at the court's jurisprudence on free speech, it almost always gets, well, and actually it almost gets, but it gets a lot more protection than a lot of other rights than that are in the Constitution. So I just think that the decision reflects a difference in culture, and I think that it is very hard, a very difficult decision to administer for a Google in particular.
It is difficult to administer, but Google has come to accept it. Kate, Google is now saying we can live with this decision. They have an army of lawyers who I'm proud to say are overseen by a former GW Law student of mine, Keith Enright, who's just doing a great job under very difficult circumstances. But basically, lawyers in Mountain View are deciding on a case-by-case basis what violates people's dignity and what's in the public interest. Kate, maybe can you defend this right from a European perspective?
Well, I'm no expert in European law, and I'm not actually European, but
you can play
from
one
the
on
colonies,
TV.
But I don't know. It is. I mean, they're great lawyers. They have 750. They're amazing legal teams. So I guess they have a lot of capacity there. It is definitely one of these issues where the internet it brings to a head these clashes of things that the First Amendment and an interpretation of that as free speech is really very different from a European or an international understanding of free speech. And I guess, coming from the Australian perspective, we have a much more limited interpretation of freedom of speech. And that's, after spending some time in the US, you realize how different that is. Even though on the face of it, you think, oh, we share the same sorts of values and things. And then you realize, actually, no, the freedom of speech is interpreted very differently. And I think this is really bringing to a head those differences where the things that are held as being, extremely important here actually have many more limitations on them under international law and under European law. And so I think that's a really, it's valid, I think, for those other countries to be able to have their clearly valid interpretations of the freedom of speech. It's under international law. It's not to say that the US interpretation is incorrect either, but they're both valid. And so how do you, that clash of different interpretations and laws, how do you balance the fact that now this information flows so freely across the borders?
Oren, do you agree with Kate that both interpretations are valid and 1,000 flowers should bloom, or do we need a little bit of American free speech imperialism?
On this issue, go imperialism. I mean, I think I have the U.S. lawyer's perspective of the First Amendment, and so from a First Amendment standpoint, how can the government force a private party to remove truthful information because a private party does not want people to know things about them? The whole notion of the First Amendment is that the government can't do that, and so my own views of the issue just reflect that. Whether I'm not saying it's the universally correct answer, but certainly from a perspective of the U.S. traditions and the U.S. Constitution, it's the only one we can have within that tradition.
Or doesn't it depend, though, on what the meaning of imperialism is? Meaning, if the Europeans had decided to limit their right, or the obligation to remove information to just information accessible from Europe, what about, is it American imperialism to say you got to stop at the border?
Yeah, so, I mean, now I got to backtrack my whole imperialism thing, which hopefully is interesting. If I later regret that I said go imperialism, I have a right to have that removed from all public record. never said that. Maybe this comes in handy from a speaker's standpoint. Clearly, there are hard questions in terms of how you implement any of these standards, right? And this is increasingly difficult on the internet when the notion of a kind of localized internet experience is one that's very easy to circumvent, and I think over time it's probably going to be harder and harder. If you go to a foreign country, you go to Google, and it might be a different version of Google, right? In France, it would be google.fr instead of google.com, and it's possible to actually have different information, or you could log it from IP addresses, for example, and just give a different internet experience based on perceived location. That's probably going to be harder and harder to maintain over time as we get more and more used to virtual private networks, and as people are using more technologies such as Tor or any other technology which hides location, hides IP address, and just makes it hard to give the localized experience. So there are a lot of implementation problems. I just mean, my go imperialism was more just the whole notion of the right to be forgotten sort of just rings false in my mind as something that a government should be doing. I recognize other governments are doing this. This is the court ruling, and implementing it is obviously the very difficult task of the providers like Google, who as a practical matter, just have to take this on.
Okay, I want to hear from Miko and Anupam on the right to be forgotten. Right now, the European Court had asked for extraterritorial application of the right to be forgotten so that content might have to be removed on google.com, not just on Google France or Google Germany. Right now, it's localized. Miko, if it remained localized as it is now, are you for or against the right to be forgotten?
Well, I think I'm generally against the right to be forgotten, because I think that, as an American, I think that if there's truthful information out there, there are ways in which it's relevant, and having the person trying to be able to whitewash their past, I think, has really serious implications for politics, for commerce, for all kinds of things. But I actually think the right to be forgotten, this whole debate between us and the Europeans points to a much bigger problem of the patchwork of laws under which technology companies have to operate as we operate in an increasingly global environment, and it becomes this question of how do you get certainty on what your legal framework is for companies, especially not just the Googles and Facebooks who can afford to have compliance lawyers, but for startup companies and others who are trying to be able to build a globalized presence. But laws in various countries keep shifting. You have, when you talk about, for example, data breach, you've got 50 different state standards plus the international. It becomes very hard for a company that wants to actually build a global presence to be able to comply with all those. And if you're riding on someone else's backbone, like you're in the App Store and your stuff is available everywhere, you are all of a sudden subject to all these different laws and all these different things, and you may not know when you're running afoul of things. And we have to think about what it means for innovation, that we don't have standard laws under which companies can grow and build and customers can have experiences as they travel around the world. And I think that's a real problem that we are not wrestling with, and one that the internet is, debates the internet is really forcing upon us.
And upon the last word on the right to be forgotten.
Sure. So the case comes out of Spain that goes to the European Court of Justice. So I want to use classic Spanish work, which is Don Quixote tilting at windmills. The Telegraph last week ran a story in London, ran a story of all the articles in the Telegraph that had been de-indexed from the Google search engine, with photographs and other links to about the people who were supposedly forgotten. Right? So it's, in fact, even if we have two separate cultures, the reality is that those people are not forgotten. Their wrongs are not forgotten. The ways that they came into public infamy is not forgotten in Europe or in the United States, in their local search engines and in our local search engines. It would certainly be wrong to enforce, to allow any country to enforce its speech rules on the world. The United States should not be able to enforce its speech rules on the rest of the world, certainly. But what we see in the right to be forgotten is that the top example, I just looked at this piece again this morning in the Telegraph, was a 18-year-old at Harrow who received a silver Mini the night before from his parents, and the next day was driving it on the Harrow grounds and crashed it at Harrow. And so he wanted this blot, he's now 24, 25, removed from the records, the search engine records, and he successfully got it removed. But of course, there were countless stories about this man again a decade later. So unless we want to move into a world where anyone, especially the people most likely to take advantage of this, which would be the rich and powerful, can remove negative information about themselves from the internet, from the searchable internet, I think we should, as progressives in the United States, feel that this is a poor idea. It's tilting at windmills for one, and it's bad public policy for a second. Now, every government can choose its own public policy, and Oren's not saying that, he's just advising them that our way is more sensible, and in fact is the reality on the ground nonetheless in Europe. So, and also we should also be worried, and Jeff raised this already by his question, about empowering private actors and mandating that they have teams of lawyers and non-lawyers deciding what's adequate, excessive, or no longer relevant about information, about truthful information, without requiring any standard for any judicial pronouncement on that information. And so what we're doing is empowering private actors, and under threat of legal sanction, under the GPDR in the new version that is being talked about, a threat of legal sanction of 2% of your annual global turnover, which would be quite astronomical, to remove information. And so it's actually quite remarkable that Google has refused to remove information. So it's denied some 60% of the requests that it's received. It doesn't earn money from not honoring the request. It only faces the possible sanction if it refuses to honor the request, but yet it's refused to honor most of the requests. So I think these are the realities on the ground. It's been entirely unsuccessful, and it sounds like a nice idea to kind of put up a finger in the dike of information, but it's totally unworkable.
Thank you, Anupam, for that practical warning. Anupam reminds us that although the information is removed from Google and Yahoo and other search engines and data processors, it remains up on the original posters. So that means as we move into question and answer, ladies and gentlemen, be careful what you ask. We now have about 25 minutes for your questions, so please ask them. Wendy Cavanaugh.
Thank you, and thank you all for an interesting conversation. While you were talking about surveillance powers and checks on use and release of information, I was thinking about the government's unintentional release of information about millions of federal workers. And, given their approach to leaks and espionage, you have to wonder if they should be indicting themselves. But the question is, no, but this is a real question. The question is, what kind of checks could we or should we have against unintentional, but perhaps quite negligent or maybe even reckless release of sensitive information by government agencies that are collecting a lot of information, holding on to it, not guarding it appropriately? I mean, some people might ask the same question about Snowden's ability to leak the information that he did, though I'm very grateful that he did, but this is a very different case. So what checks or protections are even possible there, or should be possible?
Oren, you've written a lot about use limitations. Why don't you start off on that?
Sure. I think the hacking episode that you mentioned just points to a shift we need in our approach to internet security and a need to focus on internet security within the U.S. government. As private sector companies are really focused on this issue now. I think there was a report recently about general counsels and what issues they're worried about, and one of the number one issues they were worried about, if not the number one issue, was data security and cybersecurity against threats, outside threats and breaches. And this is an enormous problem in the U.S. government. I guess you hope now that it's already occurred that the news will sort of make people realize, wow, we really need to do a better job with this going forward. But this is the kind of threat that we've known about for decades. Folks have been warning. I started in the Justice Department in 1998, and that was a bell that everyone was ringing. We really need to focus on data security, the threat of records being obtained by outsiders or even disloyal insiders, and we really need to monitor this better and pay more attention to it. And it's so easy not to, because you usually don't see the intrusion, and so it's very easy for the intrusion to occur, and that the person who holds the data doesn't even know about it. So hopefully this story will help us sort of focus on it. But it's one of those things that we should have been focusing on for a long time and really haven't.
I think one of the big questions is whether the entity, governmental or corporate, that failed to adequately secure data or acted negligently in securing data ought to be held liable for damages that a person suffers as a result of the theft of that data. Normally we say that the thief is the one who should be liable. Sometimes we say that the person with a duty to protect could be liable as well.
I would say on this, the question about whether or not damages, I think it goes to something that Greg mentioned, which is this question of negligence. There have been suggestions that the OPM breach of federal government employees was actually done by a foreign government, and I'm not sure that you could hold our government liable for failing to keep out a very aggressive, hostile government that is putting all its resources to try and get that information. I think that's a real challenge. There are questions about data security, but I'm not sure that damages is the right answer on that. I used to do a lot of work on security clearances, and that they hold a lot of very sensitive information on government employees, and I used to work with OPM on reform on that. And part of the reason security clearances were really slow is because they kept it all on paper. And they said to me, well, but we've never had a cybersecurity breach. And so if you don't want a cybersecurity breach, we could go back to doing it all on paper, but we'll pay a price for that inefficiency. One of the challenges on moving to internet, computer-based, right? You get the advantages of being able to access data remotely and faster processing and all the rest of that. There is a vulnerability that comes with that, and I don't know that we've done the right kind of risk assessment. And I also don't think that you're ever going to be guaranteed complete security on those things. And so the question is, you know, are you going to punish people if you can't guarantee that?
But the question is, we've known about the problem for decades, and it's getting worse and worse and worse. And we keep saying, well, we're going to do better, and we're going to try this, and we're going to try that. Money talks. And I would start with the federal government. The federal government that has the most sensitive records, federal government that has the records of people seeking security clearances, people who are in danger because the information was disclosed. I mean, there's a huge high duty to protect it at the highest level. They failed. If they were negligent, they should pay.
But there are no negligent standards in this area. Like there aren't standards. You know, you could go around and survey companies for best practices, but it's not like there's a common negligent standard for what data security should be.
Good point. For the federal government, there should be strict liability.
So can I just say that Secretary Clinton was prescient.
Well, thank you so much for your thoughtful comments. So as a layperson, I have no idea how my data might be being collected, how it might be stored, or how or if it might be used in the future. So what advice would you give for lay people in terms of just good practical things that we should be doing to safeguard our data?
I would recommend using two-factor authentication wherever possible. I would recommend not putting anything in the internet that you don't want revealed.
So what is two? I don't even know what that is. Like, what's that first thing?
So what happens is, like, if, for example, Google will do two-factor authentication for your Gmail, which means if you log into your Gmail from a new location, what they will do is they will ask you, you'll have something on your phone that gives you a special code that you would then put in when you log in, so it knows that it's really you. It means that someone can't just have your password, but then you have to have both pieces of it to be able to authenticate that it's really you to log in and access what you need.
And is that, just to answer this very practical question, is that the main thing that that we should worry about, hacking because of bad password protection?
I mean,
also phishing is another. I mean, I think cybersecurity actually is the #1 thing to be worried about generally, which was stated already. So the other major tactic used by hackers is phishing attacks, that you think you're dealing with a website that's legitimate or some app that's legitimate, and in fact, it's there for surveillance purposes.
don't click on links from people who are Nigerian princes.
Darn it.
I know, or I know they say they're giving you money. They're not.
Okay. So I'll give you a break from the security questions and bring you back to speech. So protests, marches, sit-ins, these have all been ways across American history to bring visibility to different issues that we're trying to advance. But if I wanted to protest the practices of Amazon, there's not really a way for me to do that. There's no public sidewalks in the internet. So right now there is a way. I could sit at my computer with 1,000 or several thousand of my best friends and hit reload until I crash and disrupt the system to prove my point, and hopefully someone looks it up and realizes the message I'm trying to get across. But this is actually a crime under the Computer Fraud and Abuse Act. However, some courts have been holding that things like a Facebook like are protected speech. So my question is, given that they're all nonverbal ones and zeros in the end, what do you think is, or what do you think should be, the future of civil disobedience on the internet?
Rate 'em. I think what you should be doing is responding to those questions about rating the services that you get and organizing your friends to rate the services that you get.
On what site? Yelp, which then can take them down?
So can I disagree with the premise here? I think there in fact are public sidewalks on the internet. And so there's a huge amount of speech. You can complain about Facebook on Facebook. You can complain about Twitter on Twitter. I've done both. And so you can complain at companies, you can and get responses from companies. Twitter is an enormous platform, Google, etc. You can create web pages, websites that collect, you can say, you can have a URL, Amazon sucks, and collect as many people, and have a wiki page which collects information about all the people who think that Amazon has done them a disservice. So in fact, I think there's an enormous amount of speech that's possible that may far exceed what was available on the public sidewalk before. And you can still occupy the sidewalk. You can occupy the sidewalk in DC, you can occupy it in Seattle, wherever. So I disagree with the premise.
Oren, it's such an interesting question. Do you think there's a distinction between liking on Facebook, which might be protected speech, and trying to shut down Amazon under computer crime statutes, and should there be?
Sure. I do think so, and I agree with Anupam's suggestion that actually it's easier now to protest. There's so many more ways of getting speech out that are critical of different groups or governments or whatever it is that you want to protest. The line drawn in the law is that you can't damage somebody else's property. Sort of traditional. That's a fairly traditional concept. And so the idea is, if you intentionally deny others access to a site, you're interfering with others' use of the site, and then that is where the criminal line is drawn. I hope you are able to get your views out about not liking something without damaging the thing that you don't like, or without denying other people the ability to access a site if they want to access a site. It's a matter of adding more to the conversation rather than taking away other people's ability to access the sites that they want to access. And I find that a pretty workable, intuitive line, and I agree that there's just so many opportunities. If anything, it's become kind of trite, so easy to protest something. It's so easy, wow, add a hashtag and you're part of the protest. It's not clear it actually makes an impact when it's done at that sort of low level. But I think companies now are actually more sensitive than they ever have been before to these sort of online reactions or protests, because they can so quickly build with social media. An objection can take off. A tweet can be retweeted, and you can actually get people reacting in a way that a company is watching today that you couldn't have 10 years ago or 20 years ago or 50 years ago, when you could write your letter to the company, and then a year later they would write you a letter back with free samples worth 50 cents or something like that. It's really hard to generate some activity. Much easier to do it online, I think.
Time for just a few more questions.
Hi. So I was interested in you guys. You were talking about the right to be forgotten, and I was interested in that because the organization I'm working with this summer has been doing a little bit of policy research on potential American applications of the European right to be forgotten. And one of the things that we've been really concerned about is how the lack of an American right to be forgotten undermines other protections that American law has. Like, for example, if you're wrongfully convicted of a crime and then it gets expunged, or you're convicted of a crime as a juvenile and it gets expunged at the age of majority, that comes off your record. But if an employer or a school or whatever Googles you, and that information is the first thing that comes up on Google, that in a lot of ways kind of undermines the protections that come with having your record expunged or being exonerated of the thing you were said to have committed. And so my question is, how do you reconcile the fact that the important First Amendment concepts kind of say we can't have this right to be forgotten because it's Google's right to publish it, it's the news organization's right to publish this true information, with the fact that having this information so widely available and so easily accessible kind of undermines legal protections that are also super important. Thank you.
I would say in the examples that you're citing, there's a very important criteria check which we could implement, which isn't done with the Europeans, which is that it's not at the request of the individual, but you have some kind of court order saying, hey, this record is to be expunged, this person has been exonerated, therefore you need to remove the information. But the way that the European court went about it is that it didn't really give any guidance that would help people make some kind of public policy determination about when it's okay to take something down and when you need to leave something up.
Sir?
Is there a serious deterrent to things like phishing? And if so, who enforces that? And I'll use the example the other day of a entire university, which shall remain nameless, which all the mailing lists of which were phished. And unless you follow the absolute law that no matter how legitimate an incoming email looks that has links in it, don't hit any of the links, you would have gotten in trouble if you had hit any of those links. It took the university 2 days to turn around and then mail everybody on the list a warning that that email 2 days ago was phishing. And in that and it said they did a really good job of imitating our website. And in that second email were some links. And it said, please change your passwords, and you can start that process by hitting this link. Who is going to investigate that, and is it hard to figure out where a phishing expedition is coming from?
Or that's you.
Yeah, so this is a big problem that the criminal investigators have, because of course a lot of the attacks are coming from outside the United States, and it's much harder to collect evidence outside the United States because the government's authorities are strong within the border. They can get warrants or they can get subpoenas and court orders to investigate locally, whereas the folks that are sending these attacks are mostly, not all obviously, but mostly coming from countries where it's very hard to investigate the offenses. That's leading to a lot of questions within government as to how to investigate international crimes. For example, there's one rule change pending currently before the Judicial Conference that would enable search warrants to be issued by federal judges outside of their own district when anonymizing software is being used to hide the location where the crime is coming from. So that might be a case where if somebody's sending an email from, they're hiding their location, that the government might be able to help investigate that with a warrant, not knowing where the crime is actually coming from. But more and more computer crimes are involving an international component. Even when it's somebody inside the United States, it's a smart tactic to route the attack through an IP address outside the United States. So from the victim's perspective, they think the attack is coming from outside, much harder to investigate, even if it's across the street where the person's actually situated. So the evidence collection problem from the criminal investigator standpoint is made dramatically harder when there's international aspects, and so many of these cases have introduced this. And I think that's why we were talking about MLATs before, and we were talking about the government's position in the Microsoft warrant case. That's why the Justice Department wants to have these authorities. That's why they want to be able to use U.S. warrants, even when there's an international component, because so many of these cases, even just completely routine cases, you get an email in your inbox, for example, that has a phishing attack, increasingly those are having international components, making it much harder to investigate.
We have time for one more question.
This might be a really, really basic 101 question, but kind of comparing the European Union law that you talked about and U.S. law, and what you mentioned as far as there being a lot of oversight in the United States, and applying the Constitution into all of this and saying that our information, the government can't intrude, and a lot of these questions have gone into private entities, Google, Facebook, etc. What are the protections for Americans in data? Sorry. What are the protections for private entities and American in data for people? I'm not phrasing the question very well, but with Google, what oversight is there for Google, and what oversight is there for Facebook? And there was a recent case with an employer that wanted somebody to post an app on their phone that told about all of their whereabouts 24/7. Like, what oversight is there for non-government searches?
That is a superb and well-phrased and important question you ask in an age when Google and Facebook have more power over privacy and free speech than any of the governments we've been talking about, and yet they are not bound by the Constitution. Who will oversee Google and Facebook? Great way to end, and I think we want to hear from all of our panelists on that important question. Anupam.
So I think governments certainly have a very important role in overseeing Google and Facebook and all these private sector actors. The question, of course, is in the United States, the regulatory bodies here have been focused on whether or not Google is truthful about what they say they are doing with respect to the information. And so Google and Facebook are under 20-year settlement agreements with the US government, allowing for audits of their data practices. And so this is a very important measure to where the government is reviewing to ensure that Google and Facebook are being truthful with us about what they say they're doing with our data. And of course, this kind of issue is arising across the world, and you have regulators from Canada to Europe to Asia that are asking similar questions about Google and Facebook and the like. And so I think that is a really important question. I think that we also should recognize that with respect to the phishing attacks and things like that, that the companies are coming up with various measures to respond to these things. So if you use many email services, they themselves will highlight something as a phishing attack. They will signal to you that this URL doesn't match up. Or that it's going to a site that you think it's not going, that you think you're not going to. So there's a lot of stuff that the private companies are doing to try to respond to the hacking that's occurring from across the world. It might be coming from the United States, it might be coming from Europe, it might be coming from elsewhere in the world.
Great. In fact, we have just 3 minutes, so I'm going to ask everyone to be brief, but a sentence or two of thoughts about what, if anything, you would propose to regulate Google and Facebook in an age when they're not regulated by the Constitution. Miko.
I have very little to say on consumer privacy, but I would just remind everyone that if you are not paying for the service, you are not the customer. You are just a user. And so when people are using Google and Facebook, you are not paying for that service. The advertiser is paying for the service. You are the product that's being delivered to the customer for purposes of that. So when people think about, what about me? I'm a customer. What do you owe me? The business model of those companies is very different. So people should just be wary of that when they get upset about the data. So if you pay for an email service, then you are the customer, and then it's a different relationship.
Oren.
So there are laws that regulate service providers like Google and Yahoo, mostly with their relationship with the government. So they can't, for example, disclose your private records to the government at their will. They have to follow laws and only disclose in certain specific contexts. But the broader relationship is just a contract question. You know, you're contracting with a private company who you think is going to do it's going to be useful for you, and to the extent, you know, we should be watching companies and figuring out what their policies are, and transparency is really important so customers can make a choice as to what companies they want to do business with. And we've seen, I think, an increase in that. You know, we saw, for example, Facebook changed its privacy policies and people really objected, and Facebook caved and changed their policies back. And that's just maybe one example of what we're going to see going forward, of companies they're trying to make money, of course, but they need to be sensitive to the fact that customers can leave. So hopefully it'll get worked out as a contract issue.
At the same time, to counter that, there are a lot of agreements that people really don't read, and it's just, and at the end, I agree, and you don't really even know what you're signing on to. Is there really a choice?
Thankfully, the CDT does read them.
And Greg will tell them what they say in a second, but first Kate, and then Greg will have the last word.
Sure. I think that there's a real difference in terms of, and maybe that's sort of a US versus a more European perspective, in whether you're more afraid of the government or you're more afraid of big business. And I think that the approach, it's a very light touch regulatory approach for privacy protections over big business here. And I think that while market forces have a lot to play, and as users become more aware of how their data, like that they are actually selling their data to access these services, there will be increased pressure. But I also think, as you say, realistically, most people are not really engaged in thinking about the full consequences of that, and I think there probably is more space for increased regulation of it.
Greg, what do those privacy policies say in 2 sentences?
I don't know. I don't read them. And I shouldn't have to. I shouldn't have to. There should be a baseline privacy statute that we can all rely on. It can't be too prescriptive, but it should provide a baseline of protection so we don't have to read all those policies.
Great. Well, we need to stop so that we can go to the exciting plenary session. Is the Supreme Court a failure? And if so, what can be done about it? Which begins at the ballroom right afterward. Ladies and gentlemen, this has been an illuminating and wide-ranging discussion of the future of privacy and free speech. And please tweet that it was exciting rather than boring, or else we will exercise our right to be forgotten. Thank you so much.